Joining me on the panel this morning, I'm Judge Cohen, and joining me is Judge Eisnagel, who formerly was from Orange County, but now most assuredly is not in Orange or Osceola County. He's in Seminole County. And then we've got Judge Nardella, who, like myself, is a resident of Orange County. We've got two cases, interestingly enough, with the same lawyers on both cases this morning. The first case that we're going to hear is 21-720 USAA Casualty Insurance Company versus Microgeicus. And actually, I've spent the last week practicing that name, and I still got it wrong. But in any event, both sides will be entitled to up to 20 minutes each for their oral argument presentation. The appellant, we have a default for 5 minutes for rebuttal, but if you'd like something different than that, Mr. Dutton, all you have to do is just let us know and we'll give you whatever time you'd like.
The 5 minutes should be fine, Your Honor.
All right, that said, Mr. Dutton, you may proceed, sir.
Thank you. And thank you, Your Honors. My name is Scott Dutton. I have the privilege this morning of representing USAA Casualty Insurance Company, which I'll simply refer to as USAA, if I may. This matter, quite frankly, is one of surprisingly first impression in the district courts of appeal. And involves the interweavings of at least a couple statutes, but one in particular is section 627.736 C, and we get down to D, and we'll talk about the requirements of that. There are really several issues that are on appeal, but the first few sort of interweave with one another. The first issue is whether or not 627.7365 C requires providers to submit bills within 35 days of treatment. The second issue presented is that there are only two exceptions to the 35-day statutory time limit, which is actually stated in the statute itself. The third is that trial court's interpretation below contradicts district court and Florida Supreme Court interpretations of that statute, although it has not been directly addressed under the type of fact scenario here. And that it departs from the plain language of the statute, that the trial court's interpretation actually eviscerates the PIP statute, in particular, the purpose of the particular sections that we're here to talk about. And the legal opinions cited by the trial court are distinguishable and improperly read as an exception to the statute. And sort of atypical, what I'd like to do is sort of start with the statute itself. And again, going to that subsection 5, and let me tell you about subsection C in the operative part. We're going to have to go back a little bit into the history of the personal injury protection statute, and I know the 5th District in particular has been wading into those waters pretty deeply of late. But in this particular section, they put in there what was a 30-day requirement for providers to submit bills, and then they expanded it in 2001 to 35 days. And we're going to talk about that migration, but there was a reason why they put it in. And that reason is discussed by the Florida Supreme Court, by the way, in a case called Warren versus State Farm, which they took up the Supreme Court and from the 5th District Court of Appeal on several issues, and predominantly focusing on constitutionality, which is not an issue before the court today. But what the purpose of this particular section of having providers submit their bills within a stated time limit, before, again, 30 days, now 35 days, is multiple. The first one, as cited by the courts, is to avoid bulk billing. And you'll go, what does bulk billing have to do with the 35-day requirement? And it's this. What used to happen is there would be a holdback of medical bills. And there was a holdback for a couple of reasons. And that is, if a provider had what I would characterize as a multidisciplinary clinic with osteopaths, chiropractic physicians, medical doctors, and so on, as the statute was at the time, you had to have an IME within 30 days by doctors or physicians under each of those licensing chapters in order to suspend benefits. And so what would happen is they'd hold back these bills, they'd bulk bill, and boom, they'd hit them all at one time by these multidisciplinary clinics. And then it was a challenge for them to get IMEs from all of the doctors in all of those disciplines. The second thing had to do with the deductible. And so if you had bills, you would hold back your bills. And then the deductible would be expended by somebody else. And then you would submit your bills and not get hit by the deductible. There were other challenges or other reasons to do it, and that is that the insurance policies and the insurance companies have certain investigative powers, which are actually, again, part of the PIP statute. One is independent medical examinations, and the other is examinations under oath. I'm sure it won't come as a great shock to the court, but since the early or late 1990s and early 2000s, there have been issues with PIP medical providers regarding medical abuse, medical fraud, and so on. And so those investigative tools were very important. In fact, in the most recent version of the statute from 2012, they put in a 14-day rule so that you have to come on a treater's radar and ultimately on the insurers, PIP insurers' radar within 14 days so that bills would be payable. So this is what they put in the statute. Originally, it says, with respect to, and I mentioned the two exceptions, with respect to any treatment or service other than medical services billed by a hospital or provider for emergency services, that's exception number 1, as defined by 395.002, or inpatient services rendered at a hospital. The statement of charges must be furnished to the insurer by the provider. So you've got carve-out number 1 for hospitals and emergency providers that having to furnish the bills to the insurer. And again, they have to be furnished by the provider. And that the insurer is not required to pay for charges for treatment or services rendered more than 35 days before the postmark. Then there's the second exception to that. And the second exception to that comes here where it says, except the past due amounts previously billed on a timely basis under this paragraph, and except that if the provider submits to the insurer a notice of initiation of treatment within 21 days, then what the statute does, to paraphrase it, expands that period of time to 75 days. So in other words, if a medical provider sees a patient, they can file the notice of initiation of treatment, what we call a NIT.
Counsel, isn't the issue, isn't the dispositive issue here when the 35-day period begins to run?
I would say yes and no with all due respect. And let me share with you why. The 35-day, there's no question but that in the plain language of the statute, that 35-day period begins to run when the patient receives treatment. And there's only 2 exceptions under the plain language of the statute, period. That's the end of story.
And you just went through those 2 exceptions, right?
Yes, yes, sir.
Do either one of those exceptions arguably apply here?
Neither one of them apply.
The trial judge in this case equated receiving no information as to the identity of the provider with receiving incorrect information about the identity of the provider. Do you think that that was an accurate analogy?
Let me answer the question this way, that what they received was no information, not incorrect information, because that's going to lead us into...
That's the point. Is that analogous? Is receiving no information as to the identity of the provider analogous to incorrect information?
Absolutely not.
And if not, why not?
And the reason is because under the plain language of the statute, and again, respectfully reading to the court, if the insured fails to furnish the provider with the correct name and address of the insured's personal injury protection carrier, so correct name, not a name, a correct name. And because that dovetails into the provider then sending those records to the incorrect provider, which leads you into the exceptions. So if you send it to the incorrect provider, then number one, you won't fall under 1A. You'll get back a denial letter from the incorrect insurer saying that we don't have coverage. Or under 1B, proof of mailing, which may include an affidavit under penalty of perjury. Well, when you have none because you didn't receive any,
So when we're looking at the statute, you agree we need to read the entire statute, correct?
that's absolutely,
Okay.
and that's what
Is there any other indicia of meaning other than the statement, the phrase fails to furnish the provider with the correct name and address? Because opposing counsel argues, well, they failed to provide the correct name and address by failing to answer at all, right? So is there any other indicia of meaning in the statute that we could look at?
well, and you'll see where the courts talk about, and there's a reason for it, and it has to do, quite frankly, with is the insurer deciding that they're not going to seek out coverage, or in this case, is the provider. Keep in mind that the insured and their attorney was well on notice. And I think, with all due respect to the court, I don't think this court has any question in the world that the insured was put on notice vis-a-vis their attorney. Of course, the insurance company can't correspond with the insured once they're represented by counsel. But in this case, the insurer did correspond with the insured and telling them about USAA. And that
I think all the invoices were sent to the lawyer, were they not?
They were sent to the lawyer and the provider. So, so let me back up. First of all, on April 5th of 2016, before the insured ever started treatment, USAA was aware of this. In fact, if you look at the crash report, Your Honor, you'll see the crash report lists Ms. Cash as a USAA insurer.
All right. Let's go back to Judge Eisnagel's question, which I think is an excellent question, which is what in the statute beyond the language of the 35-day provision gives support for your position in this case?
The remainder of the statute, in particular regarding reasonable reliance. And that is when you look at, and if you go past the comment in that one sentence I was reading from, the provider has 35 days from the date the provider obtains that correct information. But then it says, and reading it as a whole, which Judge Eisnagel, I appreciate, the insurer is not required to pay for such charges unless the provider includes with the statement, once they ultimately get the correct information, the statement documentary evidence that was provided by the insured. Well, none was provided regarding a correct or incorrect insurer during the 35-day period, demonstrating that the provider reasonably relied on the erroneous information from the insured. And then the other part, and that's a huge thing, because if you play this out, then if you're insured, arguably, you can just leave that blank forever. And you can get 5 years down the line, 10 years down the line, 20 years down the line, and never give them the name of the correct insurer, and the bills never become due. The statute only begins to run once the insured, I guess, decides, or their attorney in this case, decides, I'm actually going to give the provider the correct name. And then when they do,
so do you interpret that as a due diligence requirement?
And in fact, some of the cases that we cited specifically refer to it in that way. A due diligence requirement on both the part of the insured, in this case their attorney, but also on the part of the provider. Because you understand what they're asking you to do, again, is just open this up and say that unless and until the insured decides to fill out some sort of information that puts this provider on notice who the correct insurer is, then everybody can avoid. Remember how I started with all those investigatory powers and the bulk billing and avoiding the deductible and all those things? Yeah, that's what they can do. So now the insurer doesn't know about it, not even under the new statute, the 14-day rule. They don't come on the radar. EUOs, when are you going to get the EUOs? 4 years from now, 3 years from now, 5 years from now? When are you going to get the IME? When are you going to stop all that? And what about the bulk billing? So then all of a sudden, all these bills that have been held back, in this case, dates of service that begin in April of 2015 up through July of 2015, it's exactly what the Warren Court talks about. Bam, you're hit with these bulk billing. And that's exactly what the Supreme Court tells you, and what the statute was exactly designed to prevent from occurring. Because in Florida, and I'm sure the courts know this, there's 4 ways to be insured. You own a vehicle that's insured under the financial responsibility laws of the state of Florida, or you live with a resident relative who's got coverage, or that you're either riding in a vehicle that has coverage, or you're a pedestrian, or in this case, riding a bicycle. These are sophisticated providers. And the insured, when you go to the sophisticated provider, but aside from that, the insured's told about USA on April 5th. And with all due respect, Judge Cohen, I think that you can see in the record, their attorney was told had multiple communications with USAA. And when USAA gets those and gets the bills, that starts as far back as May of 2015, where they sent a letter to USAA with this affidavit of non-ownership. Then again, on May 10th, they send with a bunch of the medical bills that are involved. And then USAA starts to respond to those with explanations of benefits sent back to the insurance attorney. And USAA's contention is that they were sent back by Auto Injury Solutions on USAA's behalf. That's who handles the ministerial clerical side of this, not the adjusting side, but the ministerial clerical side of getting these bills paid. And that's
Mr. Dutton, just to let you know, you are inside your rebuttal time. Use it as you wish.
Yes, Your Honor. Let me go ahead and reserve my time then in rebuttal to Mr. Barr and the plaintiff's argument in this case. Thank you.
All right, thank you, Mr. Dutton. Mr. Barr.
Thank you, Your Honor. May it please the court. My name is Chad Barr, and with me in my office is Attorney Glenn Klausman. Together, we have the privilege of representing Christos Mikrogiannakis. I think I'm saying that correctly. But as appellate counsel, I typically don't get to meet these individuals in person. But I want to just start out by saying that USAA did not request oral argument. We requested oral argument in this case specifically because of what we believed were incorrect citations to the record that were included in the initial brief, and understanding that USAA would probably respond to those, basically us calling them out on including these incorrect citations of fact in their.
Well, Mr. Barr, let me ask you this. There is no question that these bills were not submitted within 35 days, correct?
They were not submitted within 35 days of the date that treatment was rendered, correct?
Okay, so that's undisputed. Now the question becomes, do you fall under the exception provided by the statute, correct?
Correct.
Okay, and that's a legal, these are legal, issues that we need to resolve. And so I'd like you to address what is of concern to me that Mr. Dutton referenced, which is under your theory, under your analysis, you could wait, it could be a decade before these medical bills are submitted if the injured party did not list a insured. It could be, there's no time limit under your analysis, correct?
Well, I can say that there is nothing in the statute that, and not under that particular scenario, that would have a time frame for which those bills would have to be submitted.
Right. So you're, in this case, it was 18 months, right?
Correct.
Okay. But hypothetically, there would be nothing, using the analysis that you're suggesting that we utilize, there would be nothing that would prevent this from going on for a decade.
That's correct, except that
right?
you have.
Do you think that that's what the intent of the statute is?
I don't think the statute was amended the way that it was to include protections for innocent medical providers. in the situations where they're not given the correct information.
Well,
And
I don't know how innocent the medical provider was in this case. I mean, they knew that that the injured party was represented by a lawyer. They sent the invoices to the lawyer. I mean, I don't know why they couldn't have called the lawyer up to find out who the insurer was. That doesn't seem very difficult. I don't know how innocent that makes them.
well, we can't read things, into the statute that are not there. There's no duty for the medical provider to undertake those steps.
You don't think there's any due diligence requirements under this statute?
I don't. And
Okay.
especially in this particular scenario where you're dealing with an individual who's not in a car, doesn't own a car, clearly is not versed on the issues of insurance.
Well, it's not him, but he's got a lawyer. He's got a lawyer, and the provider is sending these invoices to the lawyer. So it's not his lack of sophistication that's of significance to me. When a phone call would have resolved this whole matter.
Well, the other thing we have to keep in mind too is that USAA didn't communicate with anyone that it was affording coverage under this policy, under which our client was not a named insured, was not.
Who are they going to send it to? Who are they going to send it to? When the guy comes in and leaves that blank, who are they supposed to send it to?
They send it to the attorney. That's what they do. Because just because you have an attorney doesn't mean that there is PIP coverage. So you send the bill. It could be a slip and fall case. It could be any number of situations where there's no PIP coverage and someone has an attorney. So the prudent, diligent thing to do is you send those bills to the attorney.
But counsel, isn't what typically happens in this situation that the plaintiff's lawyer is going to ask for an insurance disclosure, and that's how you find out if there's coverage?
I would assume that that's what that attorney would have done, but that doesn't necessarily create the presumption of PIP coverage because, first of all, the policy is not in the record, but the policy is not going to define my client as an insured under the policy. That's only going to be pursuant to the PIP statute.
But once they know that there's a policy out there in general, if the plaintiff's lawyer is interested in learning if that policy is going to provide coverage, he has a statutory mechanism to ask for an insurance disclosure, correct?
Sure, the attorney can ask for a copy of the policy, absolutely. And I presume that was done in this case because there was a demand for payment under the BI coverage made under the USA policy. So I assume that was done, but the medical providers generally aren't doing that. And so in this particular case, the medical provider submitted their bills to the attorney so that the attorney can then submit those to USAA under the BI coverage and get those bills paid that way. And they work that out with the attorney as it relates to payment of those medical expenses if there is no PIP coverage, which is what the presumption was all along here. And I don't think that there's any harm to the PIP insurer if these bills do take a while to get submitted. In this particular case,
Well, counsel, isn't that for the legislature to decide? I mean, we're just supposed to look at the language of the statute, right?
Well, I think we have to look at the language of the statute. We have to interpret it in a manner that does not lead to an absurd.
Right. So let's talk about that. What I can't get my head around, and I've read this exception here that we're talking about, the dispositive sort of part of the statute. And your argument seems to have some initial merit when you just read the first few phrases of the statute. But then when you read the second sentence and the A and the B, I cannot see how this language permits application in a situation where there was just no information given at all. It seems to contemplate, when talking about documentary evidence that was provided by the insured within the 35-day period, that the provider reasonably relied on, quote, erroneous information, and then A, a denial letter from the incorrect insurer, or B, proof of mailing, reflecting timely mailing to the incorrect insurer. It seems like that clearly contemplates that affirmative information was provided which was erroneous, as opposed to just leaving the question blank.
Right. And I agree in part with what you're saying. I think though, if we look at section 1, the 2 sentences that are included in section C1, and we read it in a way that says that, first of all, what is incorrect information? Incorrect information is the wrong insurer or no insurer. And then we read section 2 as applying to those situations where the patient gives the name of the incorrect insurance company. And in that situation, of course, the medical provider can timely submit the bills to the incorrect insurance company. And in fact, it has to. But the second sentence and sections A and B, subparagraphs A and B, don't apply if the patient doesn't give any insurance information. So we can read section 1 totally in harmony.
You're separating them into sections when they're not actually in sections. I mean, it's 2 sentences, right?
What I'm saying is that sentence 1 applies globally to the situation of an insurance company, or the patient giving the wrong insurance company, or the patient giving no insurance information.
But there's certainly reason to believe when reading this entire, statute here on this exception, there's certainly some indicia of meaning that supports appellant's view of the statute, that would be a reasonable. What, other than just the conclusion that you say the correct information could mean 2 things, but then the rest of this exception only addresses one of those things, is there any indicia in the language that's what the legislature was writing out here?
I don't see anything else in the global scheme of the PIP statute itself, but I think we have to look at the purpose of the PIP statute itself, which is to provide prompt payment of medical expenses to ensure that people in this situation can get on with their financial lives. So we've got the global purpose of the PIP statute, and then we have the global purpose of section C1 when it was enacted in 2001, and what that purpose was, which is to protect medical providers when they're given the incorrect insurance information. So it seems to me, just like the trial court found, and the only appellate court to have addressed this issue out of the 7th Circuit, and I know its applicability is up in the air now, but really what we're looking at is a situation where the appellant is saying only certain types of medical providers should be protected, and those are ones that were given the wrong information. And if you weren't given any information, even though that's still incorrect, then you're out of luck. And I don't think that comports.
Well, maybe what they're saying is exercise some due diligence and make an inquiry.
Well, and again, I can appreciate that, Your Honor, and I think that the diligence was done in submitting the bills to the plaintiff's BI attorney, and expecting that they would be paid that way. And I think that the statute clearly contemplates a level of expectation that medical providers are going to rely on the information that are provided by insurers when it comes to insurance information. And in this particular case, we're dealing with, it's just a very unique situation, because we're not dealing with someone that was in a car, someone who has a car. We're dealing with someone who is outside of a car. And the only way that they're covered under this policy is by virtue of, one phrase of the PIP statute found in the very beginning.
So we don't know in this case whether the lawyer gave the provider a letter of protection, do we?
No, none of that is in the record at all.
Okay. All right.
None of that is in the record at all. And Warren, USA relies a lot on Warren, but I think Warren gave us the precursor for what we are going to be dealing with today, especially when we look at, the Judge Pariente's concurring opinion and Judge Lewis' dissent in that particular case, when it talked about the situation of the medical providers getting no information or wrong information. So while that case was decided before the amendment that we're here about was enacted and subsequently renumbered, I think that this was the perception that these 2 things were lumped together: not being provided the correct insurance information, and also not being provided any insurance information, which is still incorrect information. So, and I just want to be very clear that
Well,
Any-
yeah, but if you're provided incorrect information, it certainly puts you on notice that to make inquiry. Would you agree? But you're saying that if it's no information, it doesn't, that, oh, well, you can just sit back. If you're provided the wrong information, you've got time deadlines under the statute. Do you not?
If you're provided the wrong
Wrong
insurance,
information, you've got some time deadlines based upon the statute, right?
correct.
Okay, but your argument is that if you're provided no information, there are no time deadlines, that you can sit on it for a decade or 2 decades.
Well, the relevant time frame being that you have to submit the bill within 35 days of being provided the correct information.
Okay.
But again, you're subject to a limitation of benefits. So other
So
providers,
I know, but under one circumstance, you have the statute provides for a limited time frame to make inquiry. And your argument to us is that under the other, there's absolutely no time frame.
and how could there be? Even if the legislature clearly enunciated every single scenario that could be incorrect information. And in this particular case, if the legislature said that, and it's used those words, provided no insurance information, I don't see how they would put a time frame on that at all in the first place. And so what we're dealing with is a situation where some things you just can't completely fix. And you can't put a time frame on submitting a bill when the information is not provided in the first place. So what we're dealing with here is a situation, we've got a unique set of facts. We've got the situation where USAA doesn't even tell anybody that there is coverage. They don't tell anyone that there's coverage until 2016, which is well after the treatment in this particular case. So even if there was something communicated to the BI attorney, it was not that there was PIP coverage. And you can go back through Mr. Arguto's deposition testimony. It was not communicated to anyone until 2016 that this unique person defined only by the PIP statute was cleared for coverage under this particular policy.
Counsel,
So,
I wanted to ask you another question about the language of the statute specifically. Going to your sort of reading of it, which is that the first sentence is, the way I understand your argument is the first sentence is sort of this umbrella, right? That is broader. It's a broad statement. And then I think your position is that the second sentence and the A and the B are narrow sort of, this is a specific situation. Is that correct?
that would be my argument as well as the trial court's ruling.
Okay, so my question is, doesn't the second sentence expressly refer to the first? The second sentence says, the insurer is not required to pay for such charges unless the provider includes. Doesn't that, regardless of the context of the statute, putting the context aside, doesn't that sort of express reference to the first sentence link the two and really weaken your argument?
I don't think it weakens my argument. I think it supports the conclusion that if the insurance company provided is the wrong insurance company and the provider initially submits the bills to the wrong insurance company timely, this is how you have to document what happened.
But the second sentence doesn't differentiate. You're sort of trying to say, hey, under the first sentence, there's two different scenarios. That's your reading of it. But the second sentence that the legislature passed doesn't acknowledge two different scenarios.
I would agree that the second sentence does not acknowledge two different scenarios.
But yet it references the first sentence expressly.
It references it in the context of it being the wrong insurance company.
Okay.
And so I think what we have to do is, again, look at it. We have to look at the statute. We have to interpret it in a manner that
wouldn't your argument be stronger if the second sentence said the insurer is not required to pay for such charges, and then specifically say when affirmative misinformation was given or affirmative erroneous information?
Again, Judge, I can come up with probably 15 different ways to draft this statute that would be a little bit clearer, or maybe even a lot clearer. But I think we're looking at this and saying that we have to interpret this from a perspective of what the global purpose of the PIP statute is, what the purpose of this amendment was in 2001. And we have to interpret it all together in a way that doesn't lead to an absurd or ridiculous result. And I think anything other than what the trial court concluded in this case, which is that the statute was amended to include protections for medical providers in two distinct situations, then it's absurd to allow protections for one but not for the other. And that's the basis of our argument. That's the basis of the trial court's ruling. That's the basis of the opinions that the trial court ruled on, both county court rulings as well as circuit court. And as Mr. Dutton acknowledged, this is an issue of first impression. It's not an issue that's happening every day. It's not an issue that's rampant across the state. This is a one-off situation dealing with an insured that's uniquely defined under the PIP statute, and very unique situation in terms of not even knowing that he had insurance coverage, and USA not communicating that till well after the treatment in this case was provided. So we think that the trial court's ruling is well reasoned, is in line with the intent and purpose of the PIP statute, as well as the amendment. So we would ask the court to affirm the final judgment in this case.
All right, thank you, Mr. Burr. All right, Mr. Dutton.
Thank you so much, Your Honor. And first of all, regarding what the insured knew, and again, I do want to emphasize that the insured did know, because there was imputed knowledge by and through his attorney. And the fact is that the insured and their attorney essentially, evidently, supposedly did nothing with it for over
Is
a
that
year.
knowledge required under the statute, counsel?
Is what, I'm sorry?
Where is the knowledge required by the statute, the language of the statute?
Is the knowledge, well, we're all presumed to know the law. And
I'm asking you knowledge of coverage. Where is that in the statute? I mean, you're talking about sort of notices that were provided. I'm just trying to find out what section of the statute you're talking about.
In this case, there were, and I started to, it's not as much, well, it is statutory. Every time they were submitting bills to us, that the statute requires the insurer to respond with an explanation of benefits or explanation of reimbursement.
I'm asking you
USA did that.
I'm asking you under, counsel, I'm asking you under 5C, your notices, what relevance are those under 5C, please?
I'm not tracking with you. I'm
Okay,
sorry,
that's all right. Go ahead.
Maybe my mind is just boiling up with the other stuff.
Right.
You know, for example, you pointed out.
What if you'd never given them notice? What if you'd never sent notices saying, hey, there's coverage here?
First of all, we did send notice.
I'm asking you, what happens if you didn't?
Then there has to be some due diligence on the part of the insured to determine that based upon being in a motor vehicle accident.
Does the statute require you to send notices?
Does not require us to send a notice.
Okay, that's the question I was asking you. Does the statute require you? You keep talking about the notices you sent, and I'm just asking you where that is in the statute.
It doesn't, except it does require us to send, if we receive the claim, an explanation of benefits or explanation of review, which was done. And we specifically told them, we're the insurer, you got the right insurer, and every one of the EORs or EOBs tell them, but you have to, under the statute, submit them on a CMS 1500 health insurance claims form. That's a requirement of statute. And there's literally dozens of those notices as part of this court's record. I mean, I wrote down how many times USA did it. The record in 786, record 1252, record 683, record 696, not only to them, but also to the other provider, which was stand-up. But so it's not only there, again, a record 711, record 844, record 850, record R832, record R813, repeatedly over and over again, telling them, we're the right insurer, you've submitted the claim, but you need to submit it on the form. And later, when this provider submits their claim in October of 2016, we also, well, give us the information that tells us, because what the provider didn't do, and you highlighted it, Judge Eisnagel, is this. That sentence, the insurer is not required to pay for such charges unless the provider includes with the statement documentary evidence that was provided by the insured demonstrating that the provider reasonably relied upon erroneous information. This case, they can't. They didn't, because and you've all almost hit upon the fact that there's reasonable reliance means due diligence, and due diligence in this case means that they have an attorney. You ask that question. You're a sophisticated provider who's providing treatment or care to auto accident patients, and at least make the reasonable inquiry. Otherwise, you just leave open-ended bills. And with that, Your Honor, we would respectfully request this court to reverse the trial court, and judgment should be entered for USAA on the basis that, simply put, the bills were not submitted to them on a timely basis as required by the statute.
All right, thank you, Mr. Dutton. Thank you, Mr. Barr. That's as quiet as I've ever heard Klausman since all the years I've known him. But in any event, we will. That's going to conclude this session of the court, and then we will reconvene at 11 o'clock for the next case. Thank you both for your arguments.
Thank you, Your Honor.